This is the brief on recovering lost, destroyed, or withheld land titles. While a land title is the ultimate proof of ownership, if it gets destroyed in a disaster, misplaced, or held hostage by a bad actor, Philippine property law provides very specific, precise remedies to restore your rights. First, reconstituting the government's original copy. Administrative reconstitution is basically a document disaster declaration, only triggered by catastrophic loss where at least 10% of records, or 500 titles, are destroyed. Judicial reconstitution, though, is the meticulous, everyday path for a singular lost file, requiring incredibly strict public notice to the whole world. That covers when the government loses their master copy, but what if their files are fine, and you simply lost your personal copy? Second, replacing a lost owner's duplicate. It's a simpler fix. Immediately notify the Register of Deeds, file a sworn statement of loss, and petition the court for a new duplicate carrying the exact same legal weight. But wait, what if your title isn't actually lost, but a stubborn relative or bad actor is just refusing to hand it over to you? Well, you can't legally claim it's lost if someone's holding it. Finally, to compel the surrender of a withheld title, you file a specific court petition. The absolute brilliance of this summary procedure is the court doesn't have to physically wrestle the piece of paper out of the person's hands. They just use the law to instantly render that hostage document totally worthless. Ultimately, as long as you follow the precise legal path, a missing piece of paper doesn't have to mean losing your property.
Let's talk about your land title. You know, that single piece of paper that acts as the ultimate proof that you own your property. It is your legal fortress. But what happens when that fortress gets breached? What do you do when your title is lost, stolen, or even has a mistake on it? Well, today we are diving into the exact legal tools you need to fix these critical problems.
Just imagine that heart-stopping moment. You're looking for it and you realize the single most important document for your property is just gone. Now, this isn't some far-fetched hypothetical. It happens all the time. And believe me, the next steps you take are absolutely crucial to securing your property rights.
Think of your title as the master blueprint for your property. It defines everything, the boundaries, the ownership, everything. But just like any blueprint, it can get lost, it can get damaged, or it might even have an error printed on it from the very beginning. So let's explore the specific legal tools that are designed to fix these exact problems.
We've got a really clear roadmap for this. First, we're going to pinpoint the exact nature of your problem. Then we'll get into what to do about a lost original title, then a lost duplicate. After that, we'll cover what happens when someone is holding your title hostage, or if it's just plain wrong. And finally, we'll pull it all together so you know how to choose the right fix every single time. All right, first things first. We have to correctly identify the problem. You know why? Because in the world of land titles, knowing exactly which copy has the issue is going to determine your entire legal strategy. It's that important. So here is the one thing you absolutely have to understand. There are two main copies of your title. You've got the original certificate of title. That's the official government record, and it's kept safely on file at the Register of Deeds. Then you have the owner's duplicate certificate. That's your certified personal copy, the one you're supposed to hold on to. So the first question you always have to ask is the government's copy missing or is mine? Because the answer changes everything.
Okay, so let's tackle the most serious problem first. What happens when the government's official record, that original title, is lost or totally destroyed? You know, like in a fire at the registry or a major flood. This is where a legal process called reconstitution comes into play. Its only job, its sole purpose, is to restore that lost original government copy back to its exact original state. We're not talking about creating something new here. This is all about faithfully recreating what was lost.
So how do you do it? Well, there are two paths. The first one, administrative reconstitution, is incredibly rare. It's only for those massive, catastrophic events where a huge number of titles are gone. We're talking at least 500 titles, making up 10% of the entire registry. The much, much more common path is judicial reconstitution. This is a formal court proceeding, and its final decision is legally binding on the entire world.
Now here's a critical warning. The procedure is everything. The law is incredibly strict. It demands that every single person with an interest in that property, the occupants, the neighbors, everybody, has to be notified. If the court misses even one person, or if it turns out later that the title wasn't even lost to begin with, the whole thing is void. That new title becomes completely worthless. Okay, but let's shift gears to a much more common problem. What if the government's copy is totally safe, but it's your personal copy, the owner's duplicate, that's missing?
For this situation, you need a totally different tool.
It's a petition for replacement of the owner's duplicate certificate. This is a completely different remedy than reconstitution because, remember, the original government title is not lost at all. The process for this is a lot more straightforward. First, you have to immediately notify the Register of Deeds, under oath, that your copy is gone. Then, you file a petition with the court. After a hearing where you prove the facts of the loss, the court will simply order a brand new duplicate to be issued directly to you.
And the law is crystal clear on this. The new duplicate certificate, and I'm quoting here, shall in all respects be entitled to like faith and credit as the original duplicate. So what does that mean in plain English? It means it has the exact same legal power and authority as the one you lost. For all intents and purposes, it is your new title.
All right, let's move on and tackle two other very distinct problems. What if your title isn't lost at all, but someone else has it and just won't give it back? Or what if the title you're holding has a mistake on it?
This creates a classic standoff, right? Maybe you need to register a sale, but someone is holding your duplicate title hostage and flat out refuses to surrender it. Now, it is so important to understand you can't file for a replacement or a reconstitution here. Why? Because the title isn't actually lost.
The right move here is to file a petition to compel surrender. You're basically asking the court to order that person to hand over the title. And what if they still refuse? Well, this is where the court's power comes in. It can simply cancel the copy they're holding and issue a brand new one directly to you. It's a really powerful and direct solution.
And that brings us to our final scenario. The title exists, you have it in your possession, but the information on it is just wrong. Maybe your name is misspelled, maybe your civil status has changed from single to married, or an old mortgage that you fully paid off years ago is still listed on there.
For these kinds of issues, the tool you need is a petition for amendment or alteration. And the law gives you plenty of valid reasons to file one, covering everything from simple typos to major life events like getting married or even a change in name. The whole goal is just to make sure your title accurately reflects the current true state of your ownership.
Wow, we have covered a lot of ground. So now let's put it all together, because choosing the right legal path is everything, and this next slide is designed to be your quick reference guide to get it right.
Okay, this right here is the core takeaway. It perfectly maps the 4 different problems to their 4 very specific legal remedies. So let's run through it one more time. If the government's original is gone, you need reconstitution. If your duplicate is lost, you need a replacement. If someone is withholding your title, you compel surrender. And if your title just has an error, you file for an amendment. You see? Each problem has its own specific key. So why do we keep hammering this point home? Why is getting this distinction so incredibly important? Because filing the wrong petition isn't just a minor paperwork issue. It can get your case thrown out of court, or even worse, it could result in you getting a title that is completely void and worthless. Getting it right from the very start is going to save you an immense amount of time, money, and stress. And that really brings us to the final question. Your land title is so much more than just a piece of paper. It is the legal foundation of your ownership. And knowing about these remedies empowers you to protect that foundation. So take a moment and ask yourself, is your foundation secure? Thanks for joining me.
Imagine, just for a moment, holding the most valuable piece of paper you own.
Right.
For those of you listening who are property owners, you know exactly what I'm talking about. That single document represents the absolute unquestionable proof that you own your home, or, maybe a tract of commercial land, or a family estate passed down through generations.
Yeah, it's a very tangible thing.
Exactly. You can feel the physical weight of that paper. It represents security. It represents, in a lot of cases, your entire net worth.
Oh, absolutely.
So now imagine that paper gets destroyed in a house fire, or, it gets stolen from your safe deposit box, or maybe it just vanishes during a chaotic cross-country move. The panic sets in, right? Your heart drops right into your stomach.
Naturally.
But what if I told you that losing your piece of paper isn't actually the nightmare scenario? What if the real systemic nightmare is when it wasn't your copy that burned, but the government's copy?
Yeah, that is a profoundly unsettling shift in the balance of power, really, and security. We fundamentally rely on state institutions to be the bedrock of our commercial and private lives.
Right.
So when that bedrock crumbles, when the entity that is supposed to guarantee your ownership is suddenly the one suffering from amnesia, you are left holding a piece of paper that the system just can no longer independently verify. It challenges the very foundation of property rights.
It's terrifying. And that terrifying scenario is exactly what we are wading into today.
Welcome to The Deep Dive. I'm your host, and I'm joined by our resident legal expert.
Great to be here.
We have a really dense, just fascinating stack of source material in front of us today.
We really do.
Yeah, we are looking at comprehensive legal texts, syllabi from the Ateneo Law School, Presidential Decree number 1529, which is the property registration decree, and various Republic Acts governing property registration in the Philippines.
It's a lot to unpack.
It is. And the mission of this deep dive is to basically decode the labyrinth of what the legal world calls post-registration remedies. We are going to explore how the legal machinery responds when land titles are lost, destroyed, held hostage by uncooperative parties, or, riddled with dangerous errors. And most importantly, we're going to look at how you protect your ultimate asset when the system itself faces a crisis.
And to really grasp the gravity of these remedies, we have to first establish the core philosophy of the Torrens system of land registration.
Okay, lay it out for us.
Well, this entire legal framework is built on one uncompromising pillar, and that is absolute certainty.
Certainty.
Yes. The system was designed to quiet title to land, meaning it exists to put an absolute end to questions of ownership so that commerce can flow freely without these constant paralyzing historical investigations into who owned what 100 years ago.
Right, because nobody wants to buy a house and find out some guy's great-grandfather actually owned the dirt under it.
Exactly. But when that certainty is threatened by a flood, a fire, outright fraud, or even just a clerical error, the law faces a massive dilemma. It has to balance the desperate need to restore those vital records with an intense, almost institutional paranoia about accidentally giving away someone else's land to an opportunist.
Institutional paranoia. I love that phrase.
Yeah.
Because as I was reading through these sources, the analogy that kept hitting me is that the Torrens title system is essentially a giant, impenetrable digital blockchain, but it's operating entirely on physical, vulnerable paper.
Oh, that's a really interesting way to look at it.
Yeah, like it has all the rigid, unyielding rules of a cryptographic ledger. It's designed to be immutable. But because it relies on, cellulose and ink, it's vulnerable to water damage, termites, and fire. Losing the physical paper feels quite literally like losing the private password to your entire crypto wallet.
The blockchain comparison is remarkably apt, actually. Just like a lost private key in a crypto system legally and practically locks you out of your digital assets, a break in the chain of physical paper in the Torrens system can legally lock you out of your property rights. At least it locks you out until you navigate the highly specific, often agonizingly strict procedural pathways to restore them. And the law makes absolutely no apologies for that strictness.
Because the alternative is chaos.
Right. Because a public registry that nobody trusts would just trigger the complete collapse of the real estate economy.
Okay, let's unpack this. Because the very first thing you need to figure out when you realize a title is missing is, well, whose paper is actually missing?
That's the crucial first step.
Right. The legal process you're about to face hinges entirely on this one specific detail. The Property Registration Decree, PD number 1529, outlines two entirely distinct legal universes depending on which document is gone.
Yes, Section 109 versus Section 110.
Exactly. We have to separate the owner's duplicate certificate from the original certificate. So let's look at scenario A first.
Okay.
Let's say your house is burglarized, or you lose your documents in a local flood, and only your copy, the owner's duplicate certificate, is lost or destroyed. What happens?
If that is what's missing, you fall squarely under Section 109 of the decree. This legal avenue is known as replacement.
Replacement. Got it.
And while it's generally considered the more straightforward of the two scenarios, it is still a rigorous legal undertaking. It's not just a walk in the park.
Right.
The law mandates that as soon as you discover the loss, you must send a sworn notice to the Register of Deeds of the province or city where the land lies.
So you have to tell the government immediately.
Immediately. You are essentially throwing up a flare to the system, signaling that your copy is compromised, and instructing them not to process any transactions if someone mysteriously shows up at their counter holding it.
Okay, that makes sense. Stopping the bleeding.
Exactly. And following that, you or any person with a legitimate registered interest in the property must file a formal sworn statement of the loss and petition the regional trial court.
In reading through the procedural rules, it's clear this isn't just like an administrative form you fill out at a window at City Hall.
Yeah.
You actually have to initiate a judicial proceeding.
You do. It goes to a judge.
There's a hearing after due notice.
Yeah.
You have to present evidence and actually testify before a judge that the duplicate is genuinely lost or destroyed.
Right. They don't just take your word for it.
And if the judge is satisfied with your evidence, they direct the Register of Deeds to issue a new duplicate certificate. But the fascinating detail here is that this new certificate is fundamentally marked, right?
It is. It will contain a specific permanent memorandum stating that it is issued in place of a lost duplicate.
Like a watermark of its history.
Yes, but the law explicitly states it is entitled to the exact same faith and credit as the original duplicate. It entirely restores your status quo.
It entirely restores the status quo, provided the foundation of your petition was absolutely truthful.
Ah, yes.
And this brings us to a critical jurisprudential trap that catches so many property owners off guard.
It really does.
We have to look at the landmark case of Feliciano v. Zaldivar, which is in our source material. It perfectly illustrates how unforgiving the law is regarding the definition of a lost title.
That case is foundational.
So walk us through the mechanics of the trap here. Let's say a person claims their owner's duplicate title is lost.
Okay.
They go through the motions, they file the sworn statement, they go to court. The court holds the hearing, the judge believes the testimony, and issues a brand new replacement duplicate.
A seemingly successful Section 109 petition.
Right. The petitioner walks out of the courtroom thinking they have a bulletproof title. But it turns out the original duplicate wasn't actually lost.
Oh, this happens all the time.
Right. It was just sitting in the desk drawer of a former business partner they're feuding with, or perhaps a relative who just refuses to hand it over. The petitioner essentially lied, or at best was just willfully ignorant of its whereabouts. What happens?
The Supreme Court's doctrine in Feliciano v. Zaldivar and, subsequent identical cases is absolute and uncompromising. It all comes down to the philosophy of jurisdiction.
Jurisdiction, the power of the court.
Exactly. Jurisdiction isn't just a procedural checkbox. It is the fundamental authority of the state to hear a matter and speak on it. The law dictates that a court only has the authority to issue a replacement title if the original is genuinely lost or destroyed.
Meaning if it's not actually lost.
Right. If the owner's duplicate certificate was never actually lost, but was simply in the possession of another person, then there was never any legal necessity for a replacement.
Wow.
Because the core factual requirement, the loss, did not exist, the trial court never actually acquired jurisdiction over the subject matter to begin with.
So the entire court proceeding was basically a theatrical performance with no legal weight.
That's a great way to put it.
What happens to that shiny new title the judge just signed off on?
It is entirely void. It is what the law refers to as void ab initio, void from the very beginning.
Void ab initio.
Yes, because a court operating without jurisdiction cannot issue a valid binding order. That newly printed replacement title is legally meaningless.
That's wild.
And the terrifying part for the petitioner is that a void judgment can be collaterally attacked at any time. It doesn't matter if 10 years have passed.
Wait, really? 10 years later, someone can just blow it up?
Absolutely. The legal foundation was built on a fiction, meaning the entire structure can collapse the moment the person holding the actual duplicate steps forward. You just cannot use the replacement process as a convenient workaround to bypass a messy dispute over physical possession.
That is a massive warning sign for anyone navigating property disputes. So replacing your own lost copy, scenario A, is a localized problem, but it requires absolute honesty with the court.
100%.
Now let's look at the other side of the coin. Let's talk about the systemic nightmare.
Scenario B.
Right. What happens when a massive earthquake or a fire wipes out the entire local register of deeds? This brings us to the high stakes of reconstitution, where the original certificate, the copy that physically sits in the government's filing cabinets, is destroyed. This is governed by Section 110 and Republic Act number 26.
Reconstitution is a very clinical, sterile word for a legal process that is born out of absolute chaos and historical trauma.
Yeah, it sounds like making orange juice from concentrate.
Right. But we have to remember why these laws exist. Throughout history, particularly during the destruction of Manila in World War II, and through various massive fires in provincial capitals over the decades, the government has repeatedly found itself suddenly completely blind.
Just wiped out.
They lost the very ledgers that proved who owned what in entire regions.
And this is where my brain started to rebel against the logic of the system as I was reading the sources.
How so?
Well, if I go to the local public library and I lose my library card, I just go to the front desk, pay a small fee, and ask for a replacement.
Sure.
But if the entire public library burns to the ground, the librarian doesn't call me up and say, excuse me, you need to hire legal counsel and prove to a judge that this library existed and that we had these specific books.
That's a funny way to picture it.
But it's true. Why is the immense burden of proof suddenly thrust onto the private property owner when the government is the one that failed to protect the original file?
Look, it feels inherently counterintuitive and on a personal level, deeply unfair. I get that.
It really does.
But if we connect this to the bigger picture of maintaining a functional state, the government simply has no other choice. When the registry burns down, the state cannot just take a citizen's word that they own a specific hectare of premium commercial real estate.
Because people would just lie.
Exactly. The government is forced to rely on the owner's duplicate or previously certified copies or highly specific registered deeds of transfer to painstakingly reconstruct the truth of the vanished ledger. The burden falls on the owner because the owner is now the only entity holding the surviving empirical evidence.
So the government is basically saying, we suffered massive head trauma and lost our memory. You need to bring us your family photo albums so we can remember who you are and what you own.
That captures the dynamic perfectly. And the paramount, unyielding rule of reconstitution, the golden rule governing this entire area of law, is that its sole purpose is the reproduction of a lost or destroyed Torrens certificate in the exact identical form it was in when it vanished.
Exact identical form.
Yes, it is an act of restoration, not creation. You cannot use reconstitution proceedings to subtly change your property boundaries, to alter the spelling of names, or to manifest new rights that didn't exist a millisecond before the fire started.
No sneaking in an extra acre.
Definitely not. If the title was subject to a heavy mortgage before the disaster, it must be reconstituted with that exact same mortgage intact.
Okay, so the sources outline two very different paths to achieve this restoration. We have administrative reconstitution and judicial reconstitution.
Right.
Let's tackle the administrative route first, which is governed by Republic Act number 6732.
Okay.
This process allows the Land Registration Authority to handle the rebuilding of titles without forcing citizens into a courtroom. It sounds much easier.
Well, RA 66732 was actually born out of sheer administrative necessity. The government quickly realized that forcing every single victim of a massive citywide fire to individually hire lawyers, file petitions, and clog up the dockets of the local courts was entirely untenable.
Yeah, that would be a nightmare.
It would completely paralyze the judicial system of an entire province for a decade.
So if an earthquake destroys thousands of titles, the local courts would collapse under the weight of the filings. So the administrative route acts as a pressure release valve.
Precisely.
But the law doesn't just let anyone use it, right? It's highly restricted by specific quotas.
The mathematical thresholds are very rigid. Administrative reconstitution is only available during cases of substantial loss or destruction due to force majeure events like fire, flood, or earthquakes.
Okay.
Specifically, the lost or damaged titles must constitute at least 10% of the total titles in that specific register of deeds, and the absolute number of destroyed titles cannot be less than 500.
Wait, so if a localized fire brings down a small annex of the registry and destroys, say, 499 titles, the victims are out of luck administratively. They have to go to court.
They are forced into the judicial route, yes.
Wow.
The threshold is a hard line designed to reserve the administrative bypass only for undeniable certified catastrophes. And even when you meet that threshold, the administrative path relies heavily on the owner presenting their perfectly intact original owner's duplicate copy.
So you still need your paper.
You bring your physical proof. The Land Registration Authority inspects it, verifies its authenticity against whatever secondary record survived, and essentially copies your homework to rebuild their database.
But, stepping back and looking at human nature, isn't an administrative process incredibly vulnerable?
Oh, absolutely.
I mean, the registry is literally in ashes. The city is in chaos. Without a judge rigorously cross-examining claims and demanding strict evidentiary standards in an adversarial setting, couldn't a sophisticated, opportunistic syndicate slip a brilliantly forged title into the massive pile?
And get the government to officially reconstitute a piece of land they have never owned.
Exactly.
This raises an incredibly important question about the trade-offs in property law. The answer is yes. The risk of fraud during mass administrative reconstitution is terrifyingly high.
So what stops them?
Well, what's fascinating here is how the law anticipates this exact vulnerability and attempts to mitigate it. The legislature knew it was trading absolute security for desperately needed speed. Because this process bypasses strict judicial scrutiny, the law legally brands the newly reconstituted title.
It slaps a mandatory warning label on it.
Exactly. Under Section 7 of RA 26, which applies here, any title reconstituted administratively comes with a mandatory legal encumbrance annotated right on the face of the document.
Oh, like a red flag.
Yes. For a period of 2 years from the date of reconstitution, that title is expressly subject to the rights of any person whose interest was omitted, prejudiced, or outright stolen during the chaos.
So if I am a real estate developer and I'm looking to buy a massive parcel of land and I pull the title and see administratively reconstituted 6 months ago, stamped on it, I am buying that land knowing full well that someone could emerge from the woodwork a year later with proof that the land is actually theirs.
Yes, you are buying it subject to that 2-year risk window. You absorb the vulnerability.
That's a huge risk.
It is. Only after 2 full years have passed without anyone stepping forward to file a petition asserting an omitted right, can the registered owner finally go to court and petition to have that warning label legally erased, freeing the certificate from the encumbrance and restoring its full commercial power.
It's a brilliant, if slightly nerve-wracking mechanism. It allows the local economy to restart people. People can still buy, sell, and mortgage property, but the buyer bears the risk while the dust settles.
Exactly.
But let's look at the victims of that potential fraud. Say someone does slip in a fake title during the administrative rush. The sources talk about a very specific, incredibly tight window for the true owner to fight back.
It is a breathtakingly short window, which again underscores the state's desperation to finalize these records and restore certainty.
How short?
If an interested party was unjustly deprived of their property during the administrative proceedings due to fraud, accident, mistake, or excusable negligence, they cannot wait around to build a leisurely legal case. They must file a verified petition in the proper regional trial court to set aside the administrative decision within 60 days after learning of the fraudulent decision.
60 days. That is barely enough time to hire a competent lawyer and gather evidence.
And the ceiling is even harder. There is an absolute statute of limitations. The petition can be filed no later than 6 months from the actual promulgation of the decision.
6 months absolute.
Yes. Even if the victim was out of the country and only discovered the fraud on month 7, they are entirely barred from this specific streamlined remedy.
What do they do then?
They would be forced to resort to much more complex, drawn-out, ordinary civil actions to try and reclaim their land. The Torrens system relentlessly prioritizes finality.
That is the harsh reality of the administrative route. Okay, now let's pivot to the other path. Judicial reconstitution under RA number 26.
Right.
This is the route you must take if you don't meet the 500 title disaster quota, or if your own duplicate copy was destroyed along with the government's copy. The sources repeatedly describe judicial reconstitution as an in rem proceeding.
Yes, in rem.
For those listening who deal with property, you know in rem means the lawsuit is directed against the property itself, not a specific person. But what is truly staggering here is the sheer power of that classification.
The power of an in rem proceeding cannot be overstated. Because the legal action is fundamentally directed at the physical land, the final judgment issued by the court is binding on the entire world.
The whole world.
The entire world. It does not matter if you live next door, if you are an absentee landlord living in Europe, or if you were never personally handed a summons. If the court issues a valid in rem decision reconstituting that title, you are absolutely bound by it. It constitutes constructive notice to the whole world.
And because a single regional trial court judge is wielding this godlike power to bind every human being on earth to a property decision, the law demands that the petitioner follow the procedural rules with an almost militant, obsessive strictness.
Yes, it does.
Which brings us to the agonizing jurisdictional requisites under sections 12 and 13 of RA number 26.
But the procedural hurdles are intentionally grueling. To even get the court to validly hear your case, you must publish the notice of the hearing at your own considerable expense twice in successive issues of the official gazette, at least 30 days prior to the hearing date.
And let's be honest, almost nobody reads the official gazette over their morning coffee. It is a purely legal fiction of public notice, but you still have to pay for it.
Oh, it is the ultimate legally mandated bulletin board of the Republic. Beyond that, you must physically post the notice on the main entrance of the provincial building and the municipal or city building where the land is specifically located, again, at least 30 days prior.
Okay, so publishing and post.
But the true gauntlet where the majority of these cases are won or violently lost on appeal is the mailing requirement.
Right. You must send actual physical notices, usually by registered mail, to the occupants or persons in actual possession of the property, to the owners of all adjoining properties, and to all their interested parties.
Yes.
And the notice has to be incredibly detailed, right? The loss certificate number, the registered owner's name, the exact location, the boundaries, and the strict deadline to file an objection.
And we must inject some practical reality into this requirement. If an entire registry just burned to the ground and you are attempting to judicially reconstitute your title, how do you even establish with legal certainty who your adjoining owners are?
Wow, I didn't even think of that. Their title's probably burned too.
Their title is likely burned in the exact same fire. You are forced to rely on secondary, often outdated records like tax declarations, municipal assessors' files, or physical geodetic surveys.
And the margin for error is exactly zero. I want to bring in the massive doctrines from the Supreme Court highlighted in the syllabus, specifically Tahanan Development Corps v. Court of Appeals and Alabang Development Corps v. Court of Appeals.
Yes. The exactness cases.
In these landmark cases, the Supreme Court brought the hammer down on sloppy procedure. They demanded absolute exactness and precision in these judicial notices.
The jurisprudence is terrifying for practitioners. If a petitioner fails to properly serve actual and personal notice to even one single actual possessor or adjoining owner, perhaps they missed the owner of a small strip of land in the back because they mistakenly assumed it was a public alleyway, the Supreme Court has ruled that the omitted party was fundamentally deprived of their day in court.
And the consequence of missing that one neighbor isn't just a slap on the wrist or a fine. The consequence is apocalyptic for the petitioner's title.
It is entirely catastrophic. The failure to comply strictly with the notice requirements of Sections 12 and 13 means the trial court fundamentally never acquired jurisdiction over the case.
We're back to jurisdiction again.
Always. Therefore, the resulting order of reconstitution, even if it was issued years ago, is to, quote, the court's exact, unforgiving language, utterly null and void.
Utterly null and void. Even if the petitioner went through a 2-year trial, won the case, the judge slammed the gavel, declared it final and executory, and a new title was printed.
Even then, if 5 years down the line, that omitted adjoining owner discovers what happened and successfully proves to an appellate court that they were never sent a registered letter, the entire judicially reconstituted title vanishes like smoke.
Just poof, gone.
A void judgment produces no legal effect whatsoever. It is as if the trial never happened. This highlights why navigating judicial reconstitution requires you to act as a relentless detective, meticulously tracking down every single adjacent neighbor and securing undeniable proof of notice.
Because a single missed letter renders your newly minted title a ticking time bomb.
Exactly.
Okay, let's take a breath and transition to a completely different kind of headache. We've talked extensively about what happens when your title is genuinely missing. But what if the title isn't lost or destroyed at all? What if you know exactly where it is, but the person holding it is staring you in the face and flatly refusing to give it to you?
The hostage situation.
Yes, the hostage situation governed by Section 107 of PD 1529.
This is an incredibly common, intensely frustrating scenario in real estate practice. As we established earlier with the Feliciano doctrine, you cannot simply lie to a judge and use the replacement process if a title is being withheld by an uncooperative party.
Right, you can't just say, I lost it, if your cousin is holding it hostage.
Exactly. The law has engineered a highly specific, targeted remedy for this exact standoff, and that is a petition to compel surrender.
The analogy that works best here is like a messy dissolution of a partnership or even a bitter divorce, where a former partner refuses to hand back the physical keys to a jointly owned property.
That's a good comparison.
You are legally on the deed. You have the right to access. But they hold the physical metal key. You can't just call a locksmith, pretend you dropped your keys down a storm drain, and get a new set issued while ignoring the dispute. You have to legally force the uncooperative party to hand over the original keys.
That grounds the concept perfectly. In the realm of property registration, this hostage situation typically crystallizes during transactions.
Give me an example.
Let's say you legitimately purchase a parcel of land. You pay the seller the full amount, both parties execute a notarized deed of absolute sale, and you pay the capital gains taxes.
Okay, everything's done.
But out of malice, buyer's remorse, or extortion, the seller refuses to physically hand over their owner's duplicate certificate. You take your pristine deed of sale to the Register of Deeds to transfer the title into your name, and the registry stops you cold.
They won't do it.
They legally cannot process the transfer and cancel the old title without the physical surrender of the outstanding owner's duplicate. You are paralyzed in legal limbo.
Or it happens in involuntary dealings, right? Say you successfully sue a debtor, the court levies their property, it goes to public auction, you win the bid, and you want to register the sheriff's certificate of sale. The Register of Deeds still needs that physical duplicate, which the bidder debtor is obviously hiding.
Exactly. So you are forced to go to court under Section 107.
So what happens in court?
You file the petition, and the court initiates a proceeding that is explicitly designed to be summary in nature. The court issues a direct order to the person withholding the title, commanding them to produce and surrender it.
But human stubbornness knows no bounds. What if they just ignored the judge? What if they say, I lost it? But the judge clearly sees through the perjury. Does the court just throw its hands up in defeat?
The law does not tolerate infinite defiance. If the person withholding the certificate is not amenable to the process of the court, or if they simply abscond, or if for any reason the outstanding duplicate simply cannot be delivered, the judge drops the hammer.
What's the hammer?
The court is authorized to decree the formal annulment of the withheld duplicate.
Oh, wow. The judge essentially dictates that the physical paper the person is hoarding is now legally worthless.
Precisely. The court annuls the withheld certificate and orders the Register of Deeds to issue a brand new one in its place to facilitate the pending transaction.
But what if they try to use the old one?
To ensure the general public isn't defrauded, if the stubborn party tries to sell the old annulled copy to an unsuspecting buyer, the newly issued certificate will contain a permanent, glaring memorandum explicitly noting the annulment of the outstanding withheld duplicate.
It's exactly the mechanism of canceling a stolen credit card. The physical plastic still exists in the thief's pocket, but the moment they try to swipe it at a terminal, the banking system returns a declined message. The physical object has been stripped of its institutional power.
That is the exact functional equivalent. However, if we analyze the deeper mechanics of Section 107, we must look at its critical limitations.
Okay, what's the catch?
Because this proceeding to compel surrender is summary in nature, it is built for speed. It is designed to quickly resolve situations where the withholding is purely malicious, stubborn, or baseless. But that very speed makes it legally inadequate for litigating highly complex, deeply contentious issues of actual ownership.
Give us a scenario where this summary fast track hits a judicial brick wall.
Let's return to the scenario where you bought the land, but the seller won't hand over the title. You file your summary petition to compel surrender. But at the hearing, the seller shows up with their own stack of documents and raises a massive defense.
Oh.
They claim that the deed of sale you are relying on is an elaborate forgery, or they claim that you only paid a fraction of the agreed price, and the contract is therefore rescinded.
So now it's not just about the paper.
Suddenly, the court isn't just looking at a stubborn refusal to hand over a piece of paper. The court is staring down a massive, fundamental dispute over who actually owns the land.
The sources refer to this as a genuine controversy.
Yes. When the respondent raises a genuine controversy regarding the underlying transaction or the title itself, the summary court's hands are legally tied.
Because it's too fast.
The law dictates that a judge in a fast-tracked summary hearing does not have the procedural bandwidth or the jurisdictional authority to weigh complex evidence, call handwriting experts, and decide the ultimate truth of a forgery claim. The summary petition to compel surrender must be dismissed.
The judge essentially says, this is way above the pay grade of a summary hearing. You two need to go to a court of general jurisdiction, file a full-blown ordinary civil action, conduct months of discovery, cross-examine witnesses, and thresh out the controversial issues the hard way.
It is a profoundly frustrating reality for a petitioner who thought they just needed a quick court order, but it is the necessary cost of due process. The Torrens system will not strip a citizen of their registered property rights in a fast-track hearing just because the other party filed a quick petition.
Okay, so navigating this in titles is incredibly stressful. Forcing a hostage title out of someone's hands is highly dramatic. But in all those scenarios, we are operating under the assumption that the information actually printed on the title is correct.
Right, the words are right, we just need the paper.
Exactly. We just need to find the paper or force the paper out of hiding. But let's shift to a completely different kind of crisis.
Yeah.
What if the paper exists, it's sitting safely in your vault, but the words printed on it are just wrong.
Ah, the legal nightmare of the typo that costs a fortune.
Yeah.
This brings us squarely into Section 108 of the Property Registration Decree, which governs the amendment and alteration of certificates of title. And the foundational rule here is shockingly strict.
How strict?
Absolutely no erasure, no alteration, and no amendment shall be made upon the registration book after the entry of a certificate of title without a direct formal order from the proper regional trial court.
So if a clerk at the Register of Deeds accidentally spells my name John Smith instead of John Smythe, they can't just pull out a bottle of correction fluid, fix their own obvious typo, and hand it back to me.
Absolutely not. Once that title is formally entered and attested, it is mathematically locked. Changing a single letter, adjusting a single boundary coordinate by a decimal point, requires formal judicial intervention.
That seems insane.
It seems like agonizing bureaucratic overkill for a simple spelling mistake until you analyze the system from the perspective of fraud prevention.
Right, because a spelling mistake is exactly how land gets stolen on paper. If I can casually convince a clerk that my name is Smith instead of Smythe, I might suddenly inherit the legal rights to an entirely different family's ancestral estate.
Exactly.
So the mandatory court order requirement is a massive firewall against informal, quiet tampering with the registry.
The sources outline a broad, highly specific range of valid grounds where you can successfully petition the court for an amendment under Section 108.
Like what?
You can petition if registered interests have legally terminated, for instance, if you fully paid off a 20-year mortgage, but the bank's lien is still ugly and active on the back of your title. You can petition if new interests arose that aren't reflected.
Okay, makes sense.
You can amend if the registered owner has legally changed their name, or if their civil status changed, like getting married or having a marriage annulled, provided the change doesn't prejudice existing heirs or creditors. If a corporate owner was dissolved, you must amend the title to reflect the liquidator. Or, as we discussed, if a genuine clerical error or omission was made in the typing of the certificate.
Here's where it gets really interesting for me, and I want to push the boundaries of this rule to see where it breaks.
Okay, let's hear it.
Say I am walking past a stunning, vacant, $1 million commercial lot. I go to the registry, pull the title, and I tell the judge, Your Honor, I have discovered a massive omission under Section 108. The registry accidentally omitted my name as the true, ultimate owner of this lot. Can I just file a quick amendment petition, point to the omission clause, and have the judge pencil my name in over the current owner?
It is a creative attempt, but the jurisprudence saw you coming a mile away.
I figured.
I will shut that hypothetical down by bringing in the landmark ruling from the case Blunagan v. CFI of Cebu, which is heavily emphasized in the syllabus. The core, unshakable principle you have to understand is this. Reconstitution, replacement, and amendment proceedings are universally about restoring truth. They are never about creating new truth.
Restoring the record, not litigating the rights.
Exactly. You cannot weaponize Section 108 to fundamentally alter ownership rights or to strip someone of their registered property and casually award it to yourself. In Blunagan, the Supreme Court made it unequivocally clear that a petition for amendment cannot be used to litigate the substantive issue of ownership. It is not an avenue to reopen the original decree of registration.
Meaning, whatever the land registration court decided 30, 50, or 80 years ago, when that specific parcel of land was first brought into the Torrens system, that initial decision is sacred and untouchable via amendment.
It is ironclad. The proviso in Section 108 explicitly states that nothing in this section shall be construed to give the court authority to reopen the original judgment or decree of registration.
There's no shortcuts.
If you want to claim that vacant commercial lot is truly yours, you cannot do it through the back door of a simple amendment petition. You have to file a separate, full-blown civil action for reconveyance to prove a superior title, which, against an existing Torrens title, requires overcoming an immense burden of proof regarding fraud.
But the sources also dive into a really fascinating historical evolution in how the courts handled these amendment petitions, right? Because the law didn't always function this smoothly.
Yes. There was a major, necessary historical shift in the jurisprudence. Under the old law, which was Act 496, Section 112, the rule for amending a title was governed by the doctrine of absolute unanimity.
Unanimity.
Yeah.
Meaning every single person involved has to completely agree on the typo.
Yes. Proceedings under the old Act 496 were strictly summary in nature. If you filed a petition to amend a title, say, to remove an old expired lease encumbrance, and anyone, literally any interested party, stepped forward during the hearing and said, I object, I have an adverse claim, The court's jurisdiction instantly evaporated.
Just from one objection.
Yes. The judge was forced to throw the petition out and say, "We lack unanimity. The issue is contentious. Go file a separate ordinary civil lawsuit."
So anybody, no matter how frivolous or malicious their objection was, could completely paralyze a simple amendment just by raising their hand in the courtroom.
It created massive systemic bottlenecks. Legitimate property owners were forced into years of litigation just to erase a mortgage they had already paid off, simply because a disgruntled former creditor objected. So when the new decree, PD 1529, was enacted, it revolutionized this procedural bottleneck.
How so?
Regional trial courts, acting as land registration courts, were finally granted expanded powers. They are no longer fettered by their former severely limited summary jurisdiction.
So they don't need absolute unanimity to fix the record anymore.
No. Under the current regime of PD 1529, if a substantial contentious issue arises during a petition for amendment, say, two parties are bitterly fighting over whether a specific liener should truly be canceled, the judge no longer has to dismiss the petition.
They can just decide it right there.
The regional trial court judge can hear the evidence, weigh the complex arguments, and conclusively decide the contentious issue right there within the amendment proceedings. It streamlines the administration of justice significantly and prevents bad faith actors from holding titles hostage through frivolous objections.
That structural shift makes perfect sense. It empowers the courts to actually solve the problem in front of them instead of just continuously kicking the can down the road to another docket.
Exactly.
But this logical progression leads us to the darkest, most intense part of our outline. We've talked about fixing innocent typos. We've talked about courts handling messy fights over errors. But what if the error isn't an error at all?
Oh, boy.
What if it is a deliberate, highly orchestrated, malicious attack on your property rights? Let's transition into the final major area: fraud, omissions, and the ensuing war over the title.
This is where we analyze the absolute limits of the system. What are your ultimate final remedies if your rights are secretly omitted from a title, or if a syndicate successfully wrongfully registers your family property under their own name?
The sources essentially map out an escalation of legal warfare. I see three distinct stages of retaliation available to a defrauded owner. The first is what we just touched on when amendments fail: the ordinary civil action.
Yes. If you attempt an amendment petition under Section 108, and despite the court's expanded powers under PD 1529, the issue of ownership is so deeply contested, so fundamentally fractured that it cannot be resolved through mere amendment, you must escalate. You must file a full ordinary civil suit.
This is an exhausting, all-out battle over who possesses the better legal right to own the land.
It is a marathon, yes.
Okay, stage one is the grueling lawsuit. But stage two is something that sounds almost mystical in its legal phrasing: the action for reconveyance.
Reconveyance, yeah.
Break down how this deeply powerful mechanism works. Let's say a highly organized fraudster forges my signature on a deed of sale, pays off a corrupt notary, goes to the registry, and successfully transfers my family farm into their name. My land is officially legally gone. The government ledger says they own it. What is reconveyance?
To truly understand reconveyance, you have to understand the brilliant legal fiction of implied trust. When someone fraudulently, or even through a massive systemic mistake, registers your land in their name, the Torrens system doesn't just shrug its shoulders and say, well, they beat you to the registry, you lose.
It doesn't.
No. Equity steps in to bridge the gap between strict law and fundamental justice. The law automatically creates what is called an implied or constructive trust.
Meaning, the law pretends, for the sake of justice, that the fraudsters is just holding the land for my benefit.
That is the exact legal mechanism.
Yeah.
The law looks at the fraudster and essentially dictates, congratulations on successfully manipulating the system to get your name on the certificate of title. However, because you acquired this registration through fraud, you are not the true equitable owner. You are merely holding this property in trust as a trustee for the sole benefit of the rightful owner.
And since I am the rightful owner, I can demand my property back from my involuntary trustee.
Yes. And therefore, your specific remedy is to file an action for reconveyance. You are suing in a court of equity to compel the fraudster to fulfill their legal duty as a trustee, and reconvey meaning formally transfer and execute a deed, the property, back into your rightful name. You are using the power of the courts to legally rip the title out of their hands and put it back where it belongs.
That sounds incredibly powerful. It acts as a legal homing missile that tracks down stolen property.
It does.
But wait. As I read the doctrine surrounding reconveyance, I see a massive, terrifying loophole, and it is arguably the most crucial question of this entire deep
I
dive.
know exactly what you're going to ask.
What if the fraudster is smart, fast, and understands the Torrens system better than I do? What if they steal my title, put it in their name, and then the very next day, they sell that land to a completely innocent third party? Say, a young family looking to build their first house, who checked the title, saw it was clean, and paid fair market value. Does the new family lose their life savings, or do I lose my family farm?
This scenario is the ultimate tragic climax of the Torrens system. If you ask a room full of law students or seasoned practitioners this exact question, you will see a collective wince because the legal answer feels so inherently, viscerally unjust to the original defrauded owner.
Don't get the answer.
I have to deliver the harsh, unyielding reality of the Torrens system. If the property successfully passes into the hands of an innocent purchaser for value and in good faith, your action for reconveyance is dead.
Dead, meaning I can never, ever get my family farm back.
Never. The innocent purchaser's title is protected absolutely, unconditionally by law. The moment that innocent buyer registers their deed, the steel doors of the Torrens system slam shut on your claim to the physical land.
Why? How can the legal system actively protect a stranger who bought stolen goods over the victim who was violently robbed of their inheritance?
To understand this, we have to go back to the fundamental economic philosophy of the Torrens system that we established at the very beginning of this discussion.
Absolute commercial certainty.
Absolute commercial certainty. The Torrens system was fundamentally engineered to make land a liquid, easily tradable asset. To achieve that liquidity, a buyer must only need to rely on the face of the certificate of title. This is known as the mirror principle and the curtain principle.
Mirror in the curtain.
Yes. The title is a perfect mirror of the rights, and a curtain drops behind it, blocking out all historical claims. If a buyer goes to the Register of Deeds, looks at the title, sees no warning labels, sees no adverse claims annotated on the back, and pays fair market value without any knowledge of the underlying fraud, the law must protect them.
Even over the true owner.
If the law did not protect the innocent purchaser, nobody would ever safely buy land again. Banks would never issue mortgages. Every single real estate transaction would be paralyzed by the lingering, terrifying fear that some hidden, defrauded owner from a decade ago might suddenly appear with a lawsuit and take the land away. The entire capitalist real estate economy would grind to a halt.
So it's utilitarian.
It is. The system makes a brutal utilitarian calculation.
Yeah.
It sacrifices the defrauded individual to maintain the integrity, certainty, and fluidity of the macro market.
It sacrifices the individual to protect the market. That is a staggering realization. So if my land is gone forever, what is my alternative remedy? Am I just out in the cold with nothing?
You are permanently out of your land. Your only alternative remedy at that point is to file an action for damages against the specific fraudster who stole it. You can sue them for the monetary equivalent of the farm's value.
Which, in the real world, assumes I can actually find the fraudster and assumes they haven't already laundered the money, hidden the assets, or fled the jurisdiction entirely.
Which is usually exactly what they do. Which is why preventing the stolen land from ever reaching an innocent purchaser is the most critical existential battle you can fight. And this brings us to stage 3 of our legal warfare: defensive measures. You must weaponize the registry itself to protect yourself before it's too late.
Right, because if I suspect my estranged relative or a corrupt business partner is trying to maneuver my property, I can't just politely wait for an action for reconveyance to slowly make its way through the court system. By the time I get a judge to hold a hearing, the land could be sold to 3 different innocent purchasers. How do I immediately stop the clock?
You utilize what the law provides as an adverse claim, or in specific administrative situations, a consulta.
What's an adverse claim?
If your claim or interest arose after the original registration of the land, and there is no other formal, immediate way to register it, say, a dispute over an unrecorded deed, you execute a sworn statement detailing your right to the property. You immediately take this affidavit to the Register of Deeds, and they are legally obligated to annotate it on the back of the title.
And what does that physical annotation actually achieve in the real world?
It acts as a massive, glaring, legally binding warning sign to the entire world. It completely destroys the possibility of an innocent purchaser.
Oh, because they can't say they didn't.
Exactly. If a prospective buyer looks at the title and sees an adverse claim annotated on it, they are officially legally put on notice that the property is under dispute. If they choose to proceed and buy the land anyway, the law dictates they do so in bad faith. They are buying the land entirely subject to the outcome of your claim.
So if I win, they lose.
Yes. If you win your lawsuit against the fraudster, you also defeat the buyer. They can no longer hide behind the impenetrable shield of being an innocent purchaser.
They don't just buy the land, they buy the lawsuit along with it. And the sources also mention taking a dispute directly to the Land Registration Authority in consulta. The case of A. Borneo Resources v. Court of Appeals notes that a pending consulta essentially serves the exact same function. It acts as a formal notice and warning to third parties that someone is actively claiming a better right than the currently registered owner. It freezes the commercial viability of the land until the truth is officially sorted out.
It is a race to the registry. The Torrens system heavily rewards the vigilant, the paranoid, and the proactive, and it severely, irrevocably punishes those who sleep on their rights.
Okay, we have covered a truly massive, intricate landscape of property law today. We've journeyed through the anxiety of replacing lost duplicate titles, learning the harsh lessons of jurisdiction from the Feliciano case. We've navigated the chaotic, world-binding power of reconstitution, seeing how a single missed notice in a judicial proceeding can render a title void years later under the Tahanan Doctrine.
We really covered a lot of ground.
We did. We've seen the drama of forcing a hostage title out of a stubborn seller's hands, the rigid boundaries of fixing typos under Section 108, and finally, the brutal, unforgiving economic reality of fraud, implied trusts, and the untouchable innocent purchaser.
If we synthesize all of these intricate rules and doctrines into one overarching legal philosophy, it is this. The Torrens system is a magnificent, highly engineered machine designed for macroeconomic certainty.
Right.
When you hold a clean Torrens title, you hold a highly liquid asset that banks will lend millions against and markets will implicitly trust. But you must respect that certainty as a devastating double-edged sword. The system protects you perfectly right up until the exact moment you fail to engage with its strict procedural rules.
Whether by carelessly losing your copy, ignoring a published notice in the official gazette, or failing to immediately register an adverse claim the moment you suspect fraud.
At that point, the very machinery designed to protect your property can legally, permanently lock you out of it. You cannot rely on abstract concepts of fairness or equity to save you in the Torrens system. You can only rely on absolute procedural compliance.
It is a sobering, slightly terrifying realization. The law is not a benevolent guardian. It is a strict operating system. If you don't input the right commands, it will execute without you. But before we wrap up this deep dive, I want to leave you with one final mind-bending scenario to mull over. We've talked so much about the desperate attempts to rebuild titles from ashes and memories during reconstitution. But the source material, specifically sections 18 to 20 of Republic Act No. 6657, hints at a scenario that sounds like the plot of a high-stakes legal thriller.
It really does.
Imagine this. A massive provincial registry burns to the ground. A highly valuable plot of commercial land in the center of the city goes through the arduous, expensive process of judicial reconstitution. Notices are sent, publications are made in the Gazette, extensive hearings are held. The court is completely satisfied with the evidence. A brand new, judicially reconstituted title is officially issued to a man named John Doe.
Okay, standard reconstitution.
Right. Time passes. John sells the land to a commercial developer, who sells it to a multinational corporation, who builds a massive, multi-million-dollar, 50-story skyscraper on the land over the next 20 years.
Huge investment.
Then one day, an old safe deposit box is pried open in a forgotten, dust-covered branch of a bank across town. And inside that box, perfectly preserved, untouched by the fire, is the original certificate of title. The exact piece of paper that everyone, including a regional trial court judge, swore was destroyed 2 decades ago.
The living original.
But there is a twist. The name on this perfectly preserved, legally pristine original title isn't John Doe. It's someone else entirely. So the philosophical and legal question I leave you with is this. When the state successfully and legally reconstitutes a ghost, what happens when the living original returns to claim its place? Who truly owns the skyscraper?
That is $1 million question.
Think about that the next time you hold your title and assume it's just a simple piece of paper. Keep diving deep.
Welcome to the debate. Imagine, for a moment, that a catastrophic fire sweeps through a city's government center. Just, a total disaster. And in an instant, the vault housing the Register of Deeds is, it's reduced to ash.
Oh, wow. Yeah, just gone.
Completely gone. And what burns is not just paper, right? It is the fundamental architecture of property ownership. Because in a system that guarantees land titles, what legal scholars call the Torrens system, the government is putting its absolute stamp of guarantee on a piece of paper.
Right, the state guarantee.
Exactly. If your name is on the registry, you own it. The state guarantees it. So when that registry burns, the question immediately becomes, how does a society rebuild the factual reality of who owns what?
I mean, it is the ultimate administrative nightmare. Because, property rights aren't just abstract concepts for lawyers to argue over. They are literally the collateral for the entire local economy.
Yes, absolutely.
Without the certainty of those titles, commerce simply stops. You can't sell a house, you can't secure a business loan to rebuild after the disaster, you can't even legally establish the boundaries of your own backyard. You're basically left with an economic ghost town.
And that brings us to the core of our discussion today. We are examining the intense legal battle over how a state reconstructs reality after a disaster of that magnitude. We're looking at the tension between two distinct frameworks, using the Philippine Property Registration Decree and Republic Act No. 26 as our sort of architectural models for this universal problem.
Right, the two paths.
Exactly. When reconstructing these foundational documents, should the legal system force everyone through the grueling, perfect procedural exactness of judicial reconstitution, or should it lean into a fast, pragmatic shortcut known as administrative reconstitution, which, it comes with its own heavy risks? I take the position that the strict, mandatory jurisdictional requirements of the judicial route are the only way to adequately protect the integrity of property rights.
And I argue that when you are dealing with a societal crisis, the scalable, built-in safeguards of administrative reconstitution provide a vastly superior, far more realistic response. Absolute perfection is, it's an illusion that will paralyze a recovering economy.
Well, to understand why perfection is necessary, we have to lay out how judicial reconstitution actually works. When a certificate of title is lost or destroyed, going through the courts is the gold standard. It's a proceeding in rem, which is a Latin term meaning the lawsuit is directed against the property itself, not against a specific person.
Right, the whole world is basically on notice.
Exactly. Because of that, the resulting judgment binds the entire world. If the judge signs the order, no one on earth can come back and claim they weren't aware. And because it wields that kind of absolute reality-altering power, the law demands strict and mandatory compliance jurisdictional requisites. You cannot simply, walk into a courtroom, tell a judge your title burned, and ask for a new one.
No, far from it. The hurdles are immense, and frankly, they're exhausting.
But they are exhausting by design. Think of judicial reconstitution like the physical world's version of blockchain verification.
Oh, that's an interesting comparison.
Right? It takes massive computational energy, in this case, time, money, and legal effort, to get every node in the network to verify the transaction. Under Sections 12 and 13 of RA 26, you must publish the notice of hearing in the official government gazette twice, at least 30 days before the hearing.
Which is not cheap, by the way.
No, not at all. You have to physically post notices on the main entrances of the provincial and municipal buildings. And, crucially, you are required to send actual personal notices by registered mail to the occupants, the possessors, the adjoining owners, and literally all interested parties.
It's a logistical mountain.
It is. I see why you might look at that and see a bureaucratic nightmare, but let me give you a different perspective. Anything less than this exactness risks the very foundation of the Torrens system. If you fail to strictly follow even one of these requirements, the court's order is completely null and void. That absolute strictness is the only reliable shield we have to protect innocent people from having their land stolen in the chaos following a disaster.
I come at it from a completely different way. The strictness you just described isn't a shield. In a real-world disaster, it's a straitjacket.
A straitjacket?
Yeah, because administrative reconstitution, which is governed by RA 6732 and RA 26, is a far more functional mechanism because it acknowledges reality.
We aren't talking about a single homeowner misplacing a document. The administrative process is explicitly reserved for cases of substantial loss or destruction due to force majeure.
Right, fire, flood, that sort of thing.
Exactly. Black swan events like massive fires or earthquakes. The law specifically requires that at least 10% of the total titles in the registry must be damaged, and numbering no less than 500 titles before this process can even be triggered.
I'm really glad you brought up the 500 title minimum because it highlights exactly why this process is dangerous. It operates on an industrial scale.
But that scale is exactly what prevents localized corruption. Why mandate 500 titles? Because it stops a corrupt local official or, a fraudulent developer from intentionally setting fire to a single filing cabinet just to destroy the records of a prime piece of commercial real estate they want to steal.
Okay, I see the logic there, but
It requires a verifiable, catastrophic event. And when that event happens, the judicial process you championed simply paralyzes the state. If 5,000 titles burn in a municipal fire, you cannot dump 5,000 complex in rem petitions onto the dockets of the local trial courts. The local economy won't survive the decade it will take to process them.
so your solution is to just, abandon due process for the sake of speed?
Not abandon, adapt. Look, administrative reconstitution operates more like a credit card pre-authorization. It lets you make the transaction and restore economic normalcy immediately, but it holds a pending charge just in case there's a dispute. That pending charge is Section 7 of RA number 26. Instead of pretending a rigid court procedure flawlessly notified everyone in the world, the administrative route places a specific 2-year encumbrance, basically a giant warning label, directly on the face of the newly reconstituted title.
But that warning label ruins the commercial viability of the title.
It openly invites any omitted rights to be asserted. It is honest about its temporal vulnerability, which makes it vastly superior to the illusion of judicial perfection.
Okay, let's look at the actual finish line here. Because you are dismissing what happens when a judge finally bangs the gavel. Once a valid judicial reconstitution is granted, the order doesn't just evaporate.
Sure.
There is a 15-day period after the local Register of Deeds and the National Land Registration Authority receive notice of the judgment. Once that period lapses without an appeal, that judicial order constitutes constructive notice to the whole world. It is final in law.
Final in theory, maybe.
No, final in law. Building a judicially reconstituted title is like building a house on a bedrock foundation. Yes, the excavation is brutal. You have to measure the publication, the posting, the individual mailings with absolute precision. But once that house is built on that bedrock, it cannot be shaken. You have a title that banks, buyers, and commerce can trust unconditionally.
But
by deliberately clouding the title with a 2-year encumbrance, your administrative process builds on shifting sand. Banks do not want to lend against a title that has a warning label saying someone else might claim it within 24 months. You are trading permanent legal certainty for temporary bureaucratic speed.
Wait, let me get this straight. You claim judicial reconstitution is a bedrock foundation, but the source material explicitly reveals how brittle that bedrock actually is. Let's go back to those mandatory mailing requirements you praised earlier.
Okay.
What happens if the petitioner makes a tiny, honest mistake? What if just one actual possessor or one adjoining farmer is not properly served with actual and personal notice via registered mail?
Well, the jurisprudence is unwavering on this. If an adjoining owner isn't notified, they are deprived of their day in court. The court never acquires jurisdiction over them.
Exactly. And the consequence of that missed registered letter is that the entire order of reconstitution is, quoting the legal texts, utterly null and void.
Yes, because due process wasn't served.
But think about the absurdity and the stakes of what you're defending. A buyer could purchase a commercial plaza, secure a multi-million-dollar mortgage to build a shopping center, and 10 years later lose it all because a postman failed to deliver a registered letter to a single neighboring owner during the reconstitution process a decade prior?
That's a rare hypothetical.
Through a full trial, even if the 15-day appeal period lapsed, even if the judge declared it final and executory, your bedrock simply shatters like a glass floor. That makes judicially reconstituted titles a hidden trap. Buyers think they are perfectly safe because a judge signed an order, but a procedural technicality from a decade ago can void the whole thing.
I mean, that's...
The administrative encumbrance, on the other hand, is transparent. It tells the market exactly what the risk is and places a firm expiration date on it, 2 years. After 2 years, the warning label drops off.
Okay, I see where you're going with the transparency argument, but you are framing the penalty of voiding the title as a flaw. It is a feature.
A feature?
Yes, the absolute terror of losing a multi-million-dollar investment 10 years later is exactly what forces petitioners and their lawyers to be exhaustive. It forces them to find every single neighbor. But your reliance on administrative speed completely ignores human nature. What happens when a title isn't actually reduced to ash in a burned building, but is simply locked in the safe of a bitter ex-spouse who refuses to hand it over?
Well, reconstitution is strictly for lost or destroyed titles.
Correct. But fraudulent actors don't care about definitions. If you try to use administrative reconstitution for a title that is merely being withheld by an uncooperative party, say a stubborn co-owner or a seller who refuses to hand over the document after you've paid them, you are committing fraud upon the registry.
Right, which is why that's illegal.
And the proper legal remedy is found in Section 107 of the Property Registration Decree. It requires a petition in court to compel the surrender of the withheld duplicate certificate.
And if they refuse to surrender it, the court can annul it?
Yes, the court holds a hearing. If the person withholding the duplicate ignores the court's order, the judge can decree the annulment of the withheld document and issue a new one. But here is the critical filtering mechanism of the judiciary. These proceedings are summary in nature. They are meant to be quick.
Provided there's no major dispute.
Exactly. If the person withholding the title shows up to court and raises a genuine controversy, say they dispute the ownership entirely, or they claim the sale was forged, the summary petition must be dismissed immediately. The parties are then forced to thresh out their highly contentious issues in an ordinary, full-blown civil trial.
Right.
The court's ability to discern these contentious issues up front, to look a person in the eye and differentiate between a genuinely lost document and a heavily disputed property, prevents bad actors from using a fast administrative process as a backdoor to steal land.
But that assumes the administrative process is just a blind rubber stamping free-for-all, which, it fundamentally is not. Administrative reconstitution doesn't ignore fraud, it simply shifts the timeline to a more practical place. Let's look at the specific attack windows provided against an administratively reconstituted title.
The attack windows are incredibly short.
Beyond the immediate 15-day appeal window to the Land Registration Authority, the law provides a highly specific, targeted mechanism. If any interested party was unjustly deprived of taking part in the administrative proceedings due to fraud, accident, mistake, or excusable negligence, they can file a verified petition in the regional trial court to set the administrative reconstitution aside.
But look at the window they are given. They must file within 60 days after learning of the decision, and absolutely no later than 6 months from its promulgation. That places a massive burden of vigilance on a rightful owner who might be completely unaware their land is being stolen.
It places a reasonable burden of vigilance in the aftermath of a mass disaster. This is about triage. If 5,000 titles burn in a citywide fire, 4,900 of them probably have no disputes whatsoever. They are just regular people who need their paperwork back to rebuild their homes.
You can't just assume those numbers.
But the principle stands. The administrative route lets those 4,900 uncontested titles be reconstituted swiftly so society can function. It reserves the heavy machinery of the courts and the years of delays that come with it only for the 100 cases where actual proven controversies exist, like the bitter ex-spouse or the forged sale you mentioned. Why would you force 100% of the population to endure a grueling, expensive judicial gauntlet just to catch the 2% of bad actors?
I'm not convinced by that math, because the legal system isn't just a machine for processing paperwork efficiently. It is the ultimate arbiter of truth. When we talk about reconstructing property rights, we have to look closely at Section 108 of the Property Registration Decree, which deals with amendments and alterations of certificates.
Section 108, right.
This section reveals the deep philosophical commitment of the entire Torrens system.
You're referring to the strict prohibition on erasures?
Yes, exactly. The law explicitly states that no erasure, alteration, or amendment
shall be made upon the registration book after the entry of a certificate of title. Think about what that means. If a registered interest has terminated, if a new interest is created, if there was a simple clerical error in entering a memo, or even if the registered owner simply gets married or divorced and needs to update their civil status, any of these minor changes require a formal court petition.
Which is incredibly tedious.
But necessary, and the judge must notify all parties in interest before ordering the cancellation or entry of a new certificate. But the statute contains a massive, unyielding limitation. Section 108 shall not be construed to give the court authority to reopen the original judgment or decree of registration. The original decree is sacrosanct.
Right, it can't touch the original decree.
The court acts as an intense gatekeeper precisely to ensure that a simple amendment doesn't accidentally or intentionally reopen the settled reality of who owns the land. If the law demands a judge just to update a registered owner's last name after a wedding, how can we possibly justify bypassing the judiciary entirely when reconstructing the title from scratch?
That is a compelling philosophical argument, I'll give you that. But I think you're ignoring the practical reality found in the very next section of the law. You lean heavily on Section 108 strictness, but pivot with me to Section 109 and Section 6 of Republic Act No. 26. This fundamentally undermines the idea that we always need a judge to hold our hands.
Section 109 deals with the replacement of a lost duplicate certificate, not the original in the vault.
True, but let's connect the mechanics. Under Section 6, if the original title in the government vault burns down, but the property owner still has their pristine, authentic owner's duplicate copy sitting safely in their personal fireproof safe at home, they can use that duplicate as the foundational source for administrative reconstitution.
Well, yes.
And the law explicitly states that in this specific scenario, it requires no other requisite. No publications in the Gazette, no mass postings on bulletin boards, no mailing registered letters to the farmers next door.
Because the owner's duplicate is legally considered an authentic replica of the original. The evidence is absolute?
Exactly. The procedure becomes beautifully simple. The administrative officer looks at the authentic duplicate, confirms it matches the secondary records, and simply reconstitutes the original. You are assuming that judicial gatekeeping always equals accuracy. I argue that requiring the full adversarial judicial machinery for what amounts to a simple clerical matching game is massive bureaucratic overkill. The law itself recognizes that when the primary evidence is clear, the courts don't need to be involved in the act of replacing paper.
Look, I will concede that when you possess the pristine owner's duplicate, the risk is minimal. But that is a highly specific best case exception. In a true disaster, often both the vault and the homes burn.
That's true.
When you lack the owner's duplicate and you are forced to rely on secondary evidence like a previously certified copy, a registered deed of transfer, or patching together tax declarations and survey plans, the risk of catastrophic errors skyrockets. You are essentially guessing at the dimensions of reality based on shadows. That is exactly when the judicial gatekeeper is most necessary. You need a judge to weigh the validity of that secondary evidence.
I don't disagree that secondary evidence requires intense scrutiny, but you are vastly underestimating the administrative process. This isn't being handled by some random clerk. The process involves the administrator of the Land Registration Authority and specialized reconstituting officers.
They're still not judges.
But these are individuals whose entire professional existence is dedicated to land titles. They aren't just rubber stamping these requests. They are applying deep administrative expertise to verify those tax declarations and survey plans. In many ways, their specialized expertise is far more reliable for technical document verification than a general jurisdiction trial court judge who is, hearing a murder trial in the morning, a messy divorce at noon, and a complex land title dispute in the afternoon.
Expertise is incredibly valuable. I won't deny that. A specialized officer might be brilliant at reading a survey plan, but an administrative officer lacks the one thing that actually matters in property law, the binding authority of an in-rem jurisdiction. An administrative expert cannot bind the whole world. They cannot finalize reality. Only a court of law can do that.
And yet, as we discussed with the misregistered letter, The court's supposedly absolute binding authority is ultimately only as reliable as the postman who delivers the notice.
Well, it seems we have reached the fundamental core of our disagreement, which makes this an appropriate time to summarize our positions.
Sure.
My stance remains anchored in the foundational philosophy of the Torrens system. The entire economic value of a land title relies on absolute, unshakable trust. When a title is destroyed, only the strict jurisdictional exactness, the exhaustive publication requirements, and the binding finality of judicial reconstitution can provide the necessary bulwark against fraud and illegal alterations. The agonizing procedural difficulty is not a flaw. It is the very mechanism that generates the legal certainty property owners rely upon to sleep at night.
And my position is grounded in the reality of practical governance and disaster recovery. Real-world catastrophes, the kind that wipe out entire registries and devastate communities, require pragmatic, scalable solutions. Administrative reconstitution acknowledges the chaos of reality. Through its strict minimum thresholds designed to prevent localized corruption, combined with its transparent 2-year encumbrance and its targeted attack windows, it offers a resilient framework. It protects property rights at a massive scale without grinding a recovering local economy to an absolute halt.
Yet, despite our differing views on which architectural mechanism is best, we must acknowledge a crucial point of shared convergence found deep in the jurisprudence. Under both the judicial and the administrative legal frameworks, the sole exclusive purpose of reconstitution is merely to restore the instrument to its original form and condition. It is a resurrection, not a creation. Neither process creates new rights. Neither process cures existing defects in the original title.
That is absolutely correct. If your original title was flawed before the fire, your reconstituted title is equally flawed. Furthermore, both the judicial and administrative processes face the exact same ultimate limitation. If it turns out the original certificate of title was never actually lost or destroyed at all, but was simply sitting quietly in the possession of another person the whole time, the entire reconstitution is completely nullified.
Exactly.
In that scenario, the factual necessity for reconstitution vanishes. The jurisdiction, whether of the trial court judge or the LRA administrator, evaporates entirely, and the newly printed reconstituted title is legally void. Reality reasserts itself.
It is a fascinating reflection on the constant, unending tension in law. Every codal provision, every strict mailing requirement, and every 2-year encumbrance we've discussed today represents a delicate balancing act. It is the eternal struggle between ensuring perfect, unassailable due process and enabling practical, functional governance so society can move forward.
The dense legal architecture of property registration holds even more nuance for those willing to explore the material further. The intersection of absolute property rights and mass disaster recovery is just a deep well of legal complexity.
Indeed. We began today by looking at that charred vault, imagining the absolute bedrock of our property system reduced to ash. Whether you choose to rebuild that foundation with the slow, painstakingly verified exactness of a judicial decree, or with the rapid, transparent pragmatism of an administrative order, the ultimate goal remains the exact same: to give a society the confidence to once again stand firmly on its own ground.